Kia ora everybody. My name is Tuariki Delamere. I am the former Minister of Immigration for New Zealand. I am currently a licensed immigration advisor and principal consultant for TDA Immigration. This video is the first of 3 videos covering various aspects of the Accredited Employer Work Visa system that has now come into force. The first video is how do the employers get accredited. The second video will be primarily also for employers, but it is good for the migrant applicants to know about, and that's the job check approval system once the employer has been accredited. And finally, the third video will be for the potential employee, what it means and how do you apply for an AEWV, or the Accredited Work Visa. Now, people have said this is going to be an easy process. Believe me, it's not easy. It's complex and it's complicated. For sure, the first step, if you raise no red flags, that's the employer seeking the initial accreditation, that is very quick and very simple. But behind that, there is a wall of compliance requirements for the employer, which employers have never had to do before, and it'll be a shock to some of them. So let's get started. Getting migrant workers is now what I believe a 5-step process. And it is a process, I said, that is complex and complicated. Step 1, on the 23rd of May 2022, last week, applications are open for employer accreditation. Many employers have already taken the first step and been notified they've been accredited because they raised no red flags in answering the online accreditation application. Those who raised flags have a lot more stuff to put forward, and it will take time before they get accredited. Step 2, once you've been accredited, the employer wants migrants, they need to advertise each separate and distinct job type. On the 20th of June 2022, in about 3 weeks' time, applications open for employers to do their job check applications. Those of you employers who have jobs in mind, you should have already started the advertising process. Step 4, on the 4th of July, the Accredited Employer Work Visa applications open for the migrant workers. And from then on forwards, that's pretty much the only way you're going to get foreign migrants into New Zealand to do work visa type jobs. Now, this 5th step is in 12 months' time, is when you renew your accreditation, because initial approval for the employer is for 12 months. Now, there are 4 levels of accreditation for employers. Most employers will be a standard business and they will want to hire no more than 5 migrants, between 1 and 5, and they are called standard. Then you have high volume businesses which require 6 or more migrants, in some cases dozens of migrants. They are high volume accredited employers. Then you have the franchisee for businesses that are part of a franchise. And if you are in that situation, you are a franchise, then this is the way you will apply, and there are no limit as to how many migrants you can hire if you're approved as a franchise accredited employer. And then there are those employers who have a controlling third party. This is where businesses that place migrants with third parties, but they are the direct employer named in the employment agreement, but there is a controlling third party, the party where the work's actually performed. And this is another one of the 4 application processes, and there's no limit to how many migrants you can hire once you've been approved in the controlling third party category. Now let's quickly just touch on the application fees for accreditation. $740 for standard, $1,220 for high volume, $1,980 for franchisee, $3,870 for controlling third party. If you are approved as a standard accredited employer, you reach your 5 and want to then employ more, you can apply and become upgraded from standard to high volume. The fee for that is $480. If your application's been declined, the employer's application, it is $240 to have the application reconsidered. Now, applications can only be made online, and when you do the online application, if immigration require evidence, they'll ask you to upload documents to show that you meet the requirements. And there will be a lot of documents required for a franchisee and the controlling third party categories. Now, before we go on, persons who are in self-employment, if you own the company, and employers who are in the horticulture and viticulture, where you're planting, harvesting, and packing, you're not eligible for the Accredited Employer accreditation. Okay? Those in the horticulture and viticulture categories, they have their own special RSE programs to work through. The individuals, you just cannot work for yourself. You're never going to be allowed to apply. You need to find a job with an independent employer. Now, when you apply, you must have an NZBN number. The company must have an IRD number. The company must not be bankrupt. And the company or the principals must not be subject to the no asset procedure. Also, you will be asked, have you made a loss over the last 24 months? If you answer yes, then you'll have to provide evidence to show that you are a viable business. You'll also be asked then to demonstrate that you have a positive cash flow for each month of the last 6 months. You'll be asked, do you have sufficient capital or external investment funding to ensure that the business remains viable and ongoing? Or do you have a credible minimum 2-year plan, such as you've got contracts with big organizations, such as government departments, hospital boards, large multinational companies. You have to provide that information if your business has suffered a loss. And let's be realistic here. We've just gone through more than 2 years of COVID. Many businesses have suffered losses because of COVID, especially those in hospitality, tourism. And if you're in that category, don't lie and say you made a profit when you haven't, because you will be caught out. But you need to have a plan. And if you can convince Immigration New Zealand you've got a viable plan, you've got a cash flow source, you should in due course be approved as an accredited employer. Because the whole background to this is that Immigration New Zealand need to know that you are a viable and ongoing business. That means you can meet your financial obligations, you can pay the wages and other operating costs and expenses, and you can purchase the necessary stock, inventory, if that's relevant to your business. Now, the evidence you provide is up to yourself, but you will be asked to provide evidence. That will include financial statements, preferably audited, evidence of the startup capital or funding that you have available, the cash flow statement backed up by historical evidence from bank statements, a credible revenue forecast, contracts for work in the future, GST returns, income tax returns, PAYE returns, bank statements for the company, your stock lists, orders to show what you have, on hand, your lease agreements for business premises. All of these can be taken into account by Immigration New Zealand when you're trying to demonstrate that you have a genuine and viable operational business. Now here's what's never been needed before. The responsibility for the migrant workers rests very heavily now on the employers, and you must get involved in providing settlement support activities, and you are required to provide to the migrant worker that you're employing on this work visa the following information: local accommodation options. That means, you know, if the person's based in the Potiki, don't provide the vacancies for Grey Lynn in Auckland. Local transportation options, including driving and driving license information, public transportation options, information on the cost of living, how to access healthcare services, Citizens Advice Bureau services, relevant community groups, how to obtain an IRD number from Inland Revenue. And that one is in your own interest because your migrant can't work without an IRD number. Relevant industry training and qualification information and options. If that's relevant to the people you're employing, you must provide that information. And you must provide a description of the specific job or industry hazards. And of course, some industries are a lot more hazardous than others. You know, if you're working in quarries and machinery, you know, with factories machinery, you have to identify the hazards in that job. If you're working in an office, there's not much not much hazardous stuff goes on there. Okay, that is required. And you must provide it within the first month of that employee starting their employment. And if you don't do it, you're silly. Because if that employee doesn't work out, I mean, you can still, I think, give them 90 days notice for the first 90 days. But if you dismiss someone after 30 days, and it's not not a friendly dismissal, so to speak, and you haven't provided that settlement information, you could be in the gun. That employee could take you to the Employment Relations Authority, take you to Immigration New Zealand, you could lose your accreditation, and you could end up paying a lot of compensation to that employee. So don't ignore the fact you must provide this information within 1 month. Also, every employer, where they have staff who are actively involved in making employment decisions, those staff members must complete Employment New Zealand's online module on employer obligations once every accreditation period. So all of your staff who have anything involved in the employment decisions of these people who are getting the AEWV, Accredited Employer Work Visas, they must take the Employment New Zealand online module. Because again, if you don't do that, and you have a dispute with your employee sometime in the future, it could cost you big time. And you could lose your accreditation then. And don't forget, after 12 months, all those staff will have to do it again. Employees also must take the online module from Employment New Zealand. Slightly different, I believe, than one from the employers, but within 1 month of starting their employment, you must make sure that you've made it available for these employees to do those modules, and they must do them in work time. You can't tell them to go home and do it at night in their own time. It must be paid time to do those modules. And if you try to get around that, and it comes up in the future with Immigration New Zealand, the Employment Relations Authority, it's going to cost you big time. So don't try and avoid that. Just do it. Now, the employer and any key persons in the employer company cannot be included on the Immigration New Zealand's list of non-compliant employers. They must not be subject to a stand-down period for immigration offences. That's the company and the key people. They must not have employed someone in the past who was not entitled to work. They must not have provided false or misleading information to New Zealand. That's the company and any key people. And if the key people are not citizens of New Zealand or residents of New Zealand, they are themselves on work visas, they must not be acting in the breach of the conditions of the visa that they hold. And at no time can any key people have received a prison sentence for Immigration Act offences and convicted of certain other Immigration Act offences, whether you went to jail or not. You must not have a history of immigration non-compliance. You must not be banned as a company director in New Zealand or overseas. So those are all the things that the employer must not be, okay? You must have a clean record. Your employees who are involved in making decisions must have clean records. Now, a key person, what is that? It's either a director or equivalent to a director. A person who can influence decisions of directors or senior management. Okay, so trying to change directorships and shareholdings between, say, husband and wife. If one person in that couple has a bad immigration record, Immigration New Zealand are not going to allow you to continue by switching everything over to the other partner in the couple. Now, Immigration New Zealand will consider various factors, such as as being a key person. Is it a person who directs operations and financial performance? Does that person prepare statutory documents for the Companies Office, for Inland Revenue? Does that person ensure the company, the organisation complies with relevant legislation? Can that person sign contracts on behalf of the organisation? Can the person in the company who's key ensure employees must follow the company's policies and procedures? Does the person authorize purchase of inventory and other resources? Does the person receive an income based on the profits of that organization, of that company? If you have a person that meets any of those factors, that person is a key person, and they must take the employer module for Employment Relations New Zealand. And all these jobs that are, sought approval, the employer pays all advertising costs, all recruitment agency fees, the employer accreditation and job check application fees, compulsory training and induction costs that are related to the job that need to be taken, the employer pays. Health and safety equipment required for employment, the employer pays. Branded uniforms, trade testing, tools where ownership is retained by the employer. These are all costs that must be met by the employer. And Immigration New Zealand will be firm on that, because over the last 10, 15 years, there have been some employers out there have forced their staff to pay those costs. It will no longer be allowed to happen. Exploitation. The government, Immigration New Zealand, are going to do their utmost to crack down on some of the bad practices of predator exploiting employers. It's illegal to make any payment to an employer to secure employment. So it's illegal for the employee to do it, and it's definitely illegal for the employer to insist on it and take payments to secure employment. And we all know that's been going on for a long time. You can't make an employee sign a bonding agreement for an unlawful purpose. And you can't deduct from their wages accommodation, travel, or food that are unreasonable or have not been consented to in advance in writing. Okay? Happened a lot in the past. Don't do it. There are those employers out there who have a bad record, and with this new policy coming in place, some of them will try and seek to hide behind another identity and have the same business but hiding behind another name. Immigration are on the lookout for that, and if they can identify that, that company will not be accredited. Now, triangular employment arrangement is an arrangement where a direct employer places an employee with a controlling third party. Okay, and it's a complicated system, and Immigration New Zealand want to make sure that all the rules are followed and put in place. And this is where the employee is employed by the direct employer but works for another business that directs or controls the employee's day-to-day work, the controlling third party. There have been lots of those. Recruitment companies who place, temporary office staff, they come under this, the triangular employment arrangement. Labour hire employees, employment agencies, employers that place workers with subcontractors, employees seconded to a controlling third party, a parent company placing an employee with a subsidiary. Those are all examples of triangular employment with a controlling third party. A franchisee employer is one that is linked to a brand, trademark, advertising of a third party. Obviously all the fast food companies, be it McDonald's, Burger King, Domino's, Hell's Pizza, etc., they are all franchises. A lot of the petrol stations, they will be a franchisee employer because you've got a third party controlling certain activities within the business. And there's a performance or reporting obligations to the third party, an ongoing obligation to pay fees, profits to the third party, restrictions, expectations, or control imposed by the third party, and a restricted inability of the employer to refuse requests by the third party. Where any of those conditions are present, that's that's where there is a controlling third party franchisee. Now, if a business is prosecuted and Immigration New Zealand can't just fine people without taking them to court. If the fine is up to $1,000, your accreditation will be lost for 6 months. If the fine is between $1,000 and $10,000, the stand-down accreditation will be for 12 months. If the fine is $10,000 and $25,000, 18 months. And if it's $25,000 and above, then you'll be banned from being an accredited employer for 24 months. So, yeah, it's a big change. And as I said, it's not simple. Yes, at the beginning, if there's no red flags, you'll get accredited very quickly. If you're especially if you're a small business or high volume, franchisee, triangular employment, controlling third party, a lot more documentation will be required and it won't be quite so quick. But it's the follow on behind that. Okay, don't get sloppy. Don't say, oh, they're not going to follow up. I believe Immigration New Zealand or the government are very keen to shut down predator employers, and that's what this is designed for. Look, I hope that's helpful. As I said, this is the first of 3 videos. The second one will be the job check, which opens up on the, what did I say, the 22nd of June, and then 4th of July, I'll be talking about, that's when the accreditation applications open for the migrants, and that'll be the 3rd video, which will be coming out very quickly as well. So good. Stay safe, everybody. Keep masking up, because it works. Take care.